Mr. Rabinovitz.
I'm grateful to your lordships for the short addition. I think there are 4 or 5 points I need to deal with, my lord. First, in terms of a point that was suggested to me by my lord Neuberger, that in some way the existence of the statutory scheme relating to that should affect whether or not there ought to be an English law common law claim for unjust enrichment. In our respectful submissions, the answer to that is no. I've largely dealt with that in terms of the way in which Milner and Friends put it in their case. If there is to be a bar on the common law claim because of the VAT Act, then one would expect that to be because the VAT Act excludes that by virtue of Section 80, subparagraph 7. So that, in one sense, the answer to my Lord's point depends upon the proper interpretation of the VAT Act Section 87. If the VAT Act Section 87 doesn't exclude the common law claim, then in our respectful submission, there should be no other basis upon which the common law claim should be excluded, simply because there is a parallel act providing a remedy for different people, which does not exclude the claim by the commissioner, by the consumer here. In a sense, the position is no different to DMG or indeed to SEMPRA. In both those claims, one had statutes which applied to give a remedy to someone within that statute, and what the person outside of the statute was doing was to assert a common law claim. The fact that
is it giving a remedy to other people when there is an obligation, when there's the no enrichment defence? I mean, in effect, you are passing the money on to the consumer under Section 80.
Well, one presupposes that the manager wants to make the claim anyway, my lord. Your lordship is right in the sense that the consumer might be catered for in this way. But of course, it is perfectly possible for the manager not to make, or the taxpayer to make an election not to rely on EU law in a situation like this, and simply to say, I'm happy to abide by English law. In other words, that the manager, the taxpayer, manager in our case, says, I don't want to rely on Section 80. I'm happy with the position of paying tax.
Albeit he faces a claim for unjustified enrichment from the consumer.
Well, he wouldn't in those circumstances, because he would have changed his position. He would have changed his position by paying on the tax to the revenue, and the revenue would say, you're relying on the existing law, that's fine, we're the ones who received the money. I don't think you could oblige the taxpayer to make a different election in order to, by allowing the consumer a claim against the taxpayer, to put the taxpayer in that position, where the only person who's been unjustly enriched is the revenue here, the commissioners. That would be the difficulty. One would, in a sense, be undermining both English law and EU law in a situation like that, when, as I say, the people who have been enriched unquestionably here would be the commissioners. So that was the first point I wanted to deal with. The second point I wanted to deal with relates to issue 3, EU law, and the question of the principle of effectiveness and how it applies here. My Lord Mance suggested in relation to this that one reason why the principle of effectiveness might not be infringed here was because, or might have been because, it was open to the consumer, the ITCs here, to make a claim against the manager in 2001, I think it was, at a time where no one had even contemplated that there might be a claim, at a time when no one, it hadn't occurred to anyone that English law was not compliant with EU law. My lords, it is in fact no answer to a contention that the principle of effectiveness has not been met, to say to the consumer, well, you could have started a claim if only you had known about the true position. And the fact that it is only because you didn't know about the true position and didn't start a claim that you have not been able to recover and properly vindicate your San Giorgio rights. And authority for that, my lords, is the Metal-Gesellschaft case, where a similar argument was run by the UK government in the context of Metal-Gesellschaft. I think your lordships have been handed copies, you're about to be handed copies of that.
Thank you.
and indeed the lecture, which they want to put to one side for the moment, not to get distracted by the lecture.
I've already read it.
Okay.
I've already read the news.
Lordship seizes the fifth question, which was referred on page 1789, paragraph 98. The fifth question, which was put to the European Court. The National Court is seeking in substance to ascertain whether it is contrary to community law for a national court to refuse to reduce a claim brought before it by a resident subsidiary and its non-resident parent company for reimbursement or reparation of the financial loss which they have suffered as a consequence of the advance payment of corporation tax by the subsidiary on the sole ground that they did not apply to the tax authorities in order to benefit from the taxation regime which would have exempted the subsidiary from making payments in advance and did not therefore make use of the legal remedies available to them to challenge the refusals of the tax authorities by invoking the primacy and direct effect of the provisions of community law, whereupon any view national law denied resident subsidiaries and their non-resident parent companies the benefit of that taxation regime. If your lordships then go to paragraph 103, page 1791, therefore it appears that in the cases in the main proceedings, the United Kingdom government is blaming the plaintiffs for lack of diligence and for not availing themselves of legal remedies other than those which they took to challenge the compatibility with community law of the national provisions denying a tax advantages to subsidiaries of non-resident parent companies. It is thus criticising the plaintiffs for complying with national legislation and for paying ACT without applying for the group income election regime or using the available legal remedies to challenge the refusal with which the tax authorities would inevitably omit the application. Paragraph 106, the exercise of rights conferred on private persons by directly applicable provisions of community law would, however, be rendered impossible or excessively difficult if their claims for restitution or compensation based on community law were rejected or reduced solely because the persons concerned had not applied for a tax advantage which national law denied them, with a view to challenging the refusal of the tax authorities by means of the legal remedies provided for their purpose, invoking the primacy and direct effect of community law. The answer to the fifth question must therefore be that it is contrary to community law for a national court to refuse or reduce a claim brought before it by a resident subsidiary and its non-resident parent company for reimbursement or reparation of the financial loss which they have suffered as a consequence of the advance payment of corporation tax by a subsidiary on the sole ground that they did not apply to the tax authorities in order to benefit from the taxation regime which would have exempted the subsidiary from making payments in advance, and that they did not therefore make use of the legal remedies available to them to challenge the refusals of the tax authorities by invoking the primacy and direct effect of the provisions of community law, whereupon any view national law denied resident subsidiaries and their non-resident parent companies the benefit of the taxation regime. And by analogy, the suggestion that we could have brought a claim in 2001 against the manager which would have dealt with the dead period, I suppose my Lord is putting to me, would run into exactly the same problem. At that stage, English law did require this VAT to be paid, and any claim by the consumers at that stage would have been met with an answer which said, I'm sorry, English law applies, you cannot have your money back. So that was the second point I wanted to address. My Lord, the third point I wanted to address again arises in the context of issue 3, the extent of the principle of effectiveness and what it applies to and when it applies following Riemsma and Danfoss. And the first point I think to make about this, my Lords, is that it's absolutely clear from cases like Riemsma that the principle of effectiveness here would apply to the full £100. That is the amount of tax that has been taken wrongly from the ITCs. And that is the amount of tax which would have to be restored if the principle of neutrality was going to be respected. It is only by putting the consumer, the ITC, back in possession of the £100 that one gets anywhere near restoring the principle of neutrality. And it's only by doing that that you would satisfy the principle of effectiveness. And any solution which results in less than £100 being paid to the consumers would fail to meet the principle of effectiveness. Now, my Lord Neuberger suggested that in the context of Riemsma and Danfoss, it was possible that all that Reemsma and Danfoss were concerned about was the position of a disappearing taxpayer or an insolvent taxpayer. And if that isn't what my Lord Newberg was suggesting, then I do apologise. The only points I was
I
getting
wasn't
to...
aware that it was, but anyway, yes. In case it was.
My Lords, in response to that, I'd say two things. First, not even the commissioners are suggesting that Reemsma Danfoss is limited in that way. The Lordships will recall that Mr. Justice Henderson dealt with that point. I don't understand there to be any challenge that it goes beyond that. And again, your Lordships will again recall Danfoss, the Advocate General at paragraph 69, who's plainly dealing with a situation which isn't an insolvency. She's dealing with a situation in which the taxpayer would have a defence to the claim. And she said that is a situation where if you're not given a claim against the state itself, would bring into effect the requirements of the principle of effectiveness to give a direct claim against the state. And my Lords, once one appreciates that the insolvency example is just an example, if one looks at the insolvency example, again, that highlights the fact that what the principle of effectiveness is seeking to do is to ensure that the full £100 is repaid. In a situation of the disappearing taxpayer, that would be the position. We would submit, be very odd to have a situation where the position is anything different to the full £100 being restored. And of course, if one tests the position in this way, let's assume that the manager here refused to make an election. That the manager said, I'm absolutely content with what I am receiving, and I'm very happy to keep accounting for output VAT because I'm going to claim input VAT. In a situation, so one doesn't have a claim against the manager because the manager says, I'm passing this on, I'm not being enriched. In those circumstances, the San Giorgio, the consumer's San Giorgio right would require a remedy by way of a direct claim against the state. In a situation like that, there would be no possibility of offsetting the £25. The revenue would undoubtedly have been enriched by the £100, and so the remedy which would be made available to the consumer would be for the full £100. Take a situation in which instead of setting off the £25 credit in the same period, it was set off in the following period, so that a full £100 was accounted for, and the manager took a credit in the following period. Again, it would be
That
very
point
anomalous.
depends on the assertion that the ITCs didn't have a claim against the manager because you're saying the manager is disenriched. That has to be the
That has to
assumption
be
you're
right.
making.
And in my respectful submission, it's difficult to see how that would not be right in circumstances where plainly the manager has paid it on, and by acknowledging that English law is what he says it is, he couldn't possibly have a claim against the revenue.
And he's electing not to get it back.
He's electing to continue to comply with English law.
Yes, that's my point.
Well, my Lords, just want to see if there's another point. The fourth point I was going to make is this, my Lords. The way in which Section 80 works here, it would have been possible for the commissioners to have ensured that the £100 that was accounted for to them in relation to the consumers, the ITC's payment, went to the ITCs, and that they could have had a separate claim and assessed the managers for the £25. That is all machinery that was available to them within Section 80 of the Act. Now, for whatever reason, they chose not to do that. That is to say, not to use the Section 83 to ensure that £100 was paid to the manager, which was then unpaid to the ITCs, and that they separately assessed the manager in respect of the credit that he had wrongly taken for himself. In our respectful submission, my Lords, given that the commissioners could have done this in a way which ensured that the principle of neutrality was satisfied and that the ITCs were restored to their £100, and that they received back from the manager the amount by which the manager was unjustly enriched, in our respectful submission, it would be wrong to use the principle of effectiveness in a way which enabled the commissioners to arrive at a different result, whereby the ITCs are only restored as to £75 of the £100, and that whereas the commissioners could have claimed against the managers, they choose not to do so. And our respectful submission, if that is the outcome, then the problem about what has happened here is the failure of the commissioners to use the statutory resources at their disposal to ensure that they were put in the position they should have been in, where each party, in a sense, disgorged, I use that word advisedly because I know that's not what one does in restitution, but paid back the amount by which it had unduly benefited.
What about your position? Could you claim against the managers
For
£25?
Well, it depends. If the manager has accounted for the £25 to the... It goes back to issue 4. If the manager did account for the £100 and didn't get a credit, did account for the £100...
No, the manager has got it on the basis of the mistake. The manager has got an unjustified credit, which it should never have got.
We couldn't.
So why couldn't you claim from the manager?
Because if the manager is enriched by the £25, it's at the expense of the commissioners, not at our expense. Because if one looks at it in the way in which it in fact happens...
But I mean, what is the problem about simply saying this was an invoice which was rendered under mutual mistake, you must repay the sum?
Because the manager would say, you rendered me an invoice, I rendered an invoice for £100, I accounted for the £100, the revenue has got that. It is true that I have got, as well, I got a credit from the revenue in respect of £25, but to the extent that I've been enriched, it's at the expense of the commission.
So, I mean, your case comes down to this, that the only remedy in unjust enrichment is by you against the revenue, that you don't have any rights at any stage, even within 3 years or at any other time, as against the taxpayers.
It would come down to that, because they passed on, they had changed their position. And indeed, of course, as to £75 of that, the HMRC accept that. So we're only talking about the £25 element, and in our respectful submission, the position is identical in relation to the £25 element. True, it may be that there is a £25 element which may still sit with the manager.
I'm
not
not
sure
sure
they do
HMRC accept that
No.
there wouldn't have been a claim against the taxpayers for the £75.
No.
I mean, what happened was the money, the taxpayers made the claim against the revenue, got the £75 back, and in accordance with their undertaking, paid it to the to the consumer.
Well, in relation to that which has been, in a sense, paid back, they would say that there was a claim. We're talking about that part of this which hasn't been repaid. In other words, that part of it...
The dead period part.
The
dead
period part, indeed, where it is common ground, that the...
Yes, well, there they would have a change of position and defence. Yes.
My lords, those are the only points I want to make.
Very much indeed. Mr. Hitchmer. Mr. Moriarty.
My Lords, as the £25 issue is freshest in our minds, what I was proposing to do was to start by responding to the cross-appeal on that particular issue.
Yep.
And then, at the time available, reply on the points in our appeal and make a few points
Very well.
under the various headings I addressed you in opening.
Fine.
Let me divide although in a sense the European issue does come up in the context of my appeal, given the way in which it's been dealt with in the cases, in our printed cases, it makes sense, I think, for me to cover the European issue at the same time as the domestic issue on the £25 point. It really is a very short point that separates us, because the managers, as Mr. Rinovitz made clear, do expressly accept that once the manager's made an election to treat their suppliers as exempt from VAT by relying upon EU law, which of course involve the suppliers being treated exempt retrospectively, it necessarily therefore carried with it a consequence that the rated input tax it had recovered from the revenue by way of credit could be collected back by the revenue. But they say that that doesn't, at least as between the ITCs and the revenue involve some retrospective discharge of the debt which the revenue owed to the managers before the election was exercised. But the problem with that, the simple logical problem with that, is, as I think one of the noble lords said, is that it really is a case of having their cake and eating it too. Relying upon the manager's election to treat the supplies to the investment trust as exempt from VAT, with retrospective effect, as is rightly the case, so as to recover all the VAT wrongly paid before the election was made, while at the same time seeking to treat the input tax as properly deductible at the time it was made, by ignoring the retrospective effect of the manager's election until the election was made. And in our respectful submission, it's a mad result produced by a logical inconsistency. If the effect of the manager's election to rely upon EU law is to mean that all VAT paid wrongly is now to be regarded as never lawfully due, even though it was at the time, it must equally follow that the effect of the manager's election to rely upon EU law is to mean that all input tax deducted by managers is to be regarded as never legally deductible, even though it was at the time. And as I understand Mr. Rivinitz's submission, he doesn't even deny that's the case when it comes to what he calls the reckoning up as between the revenue and the managers. He just says that a different rule applies as regards a claim by the investment trusts as against the managers. And as my Lord Hodge observed in our respectful position completely rightly, that then does produce a situation where the measure of the claim against one party is different from the measure of claim against the other for no discernible reason of principle. And
you're saying basically you can't have your cake and eat it, but is that a principle of European law or
well,
sort of domestic law or both or neither?
I would actually say both, my lord. I would say as a matter of European law, when you look at the mechanism by which it said that you can't have your cake and eat it, it follows. But I'd also say as a matter of principle, it follows as a matter of English law as well. Let me just briefly develop those submissions. First of all, let's go to Becker, which is in tab 13 of bundle 2. And go to paragraph 44 at page 726. This is a paragraph that wasn't shown to you by Mr. Rabinovitz, but it deals with the question of why you can't claim input tax deduction if you're treating the output tax as exempt. In that regard, it should be pointed out that the scheme of the directive is such that on the one hand, by availing themselves of an exemption, persons entitled thereto necessarily waive the right to claim a deduction in respect of input. On the other hand, having been exempted from tax, they are unable to pass on any charge whatever to the person following them in the chain of supply, with the result that the rights of third parties in principle cannot be affected. Now, the concept of waiver there, what it's suggesting in my respectful submission is that if you are electing to treat the output tax as exempt from the provisions, you must necessarily therefore waive in relation to the input tax deductions relating to those transactions to similar effect. It would otherwise make a complete nonsense not to do so. And so the waiver is the mechanism by which the taxpayer elects, as in return for treating his output tax as being exempt, to treat the input tax as not being payable by the revenue either. Now, as a matter of principle in common law, I would suggest that one gets the analogy of, let's say, rescission of an agreement. If I enter into agreement with you to pay £500 for a picture, I then pay you the £500. I discharge my debt to you for the picture. If it turns out that as a result of a misrepresentation, I want to rescind the contract and get my money back, the effect of that is that although there was a debt that was discharged at the time I paid you, the operation of the rescission retrospectively undischarges the debt. And that's really what's happening here. It's what's happening here clearly, as Mr. Rabinowitz accepts, as between the revenue and the taxpayer. It's difficult to see any rational basis upon which the principal should act differently, operate differently, merely because it's the investment trusts who are seeking to bring a claim against the revenue and not the managers. Now, that's really all there is to say in my respectful submission, other than to deal couply with a couple of points you may like to note. No, I'll come on to that later. In addition to this point, there are two separate reasons why they say that there's no ability to recover from the managers. And the motive for this seems to be partly to support its case for saying that under European law, they must be given a direct claim against the revenue in the interest of effectiveness. And doubtless it's also partly to make the argument they have on no disenrichment seem more defensible so as to avoid the investment trust falling into a black hole. The investment trusts advance two reasons for saying that they have no claim against the managers. They say, we've had it repeated again just a minute ago, because even if the managers were enriched as to £25, it was at the expense of the revenue, not the investment trusts. And secondly, and again it was repeated a minute ago, because the managers have a defence of change of position. Now, we simply fail to understand the first point as to why it's said that the managers are enriched at the expense of the revenue as opposed to the investment trusts. The managers never received £25 from the revenue in cash. All the revenue did was give the managers a £25 credit in respect of input tax by letting the managers keep £25 of the £100 due to the revenue as output tax. Now that credit was reversed, i.e. the managers were notionally repaid £25 of wrongly deducted input tax by the revenue, when the revenue credited the managers with £100 of wrongly paid VAT, but only repaid 25. It's just as if the revenue had repaid the managers £100 and the managers had repaid the revenue £25. And so what you're left with, therefore, is the managers sitting on the £25 from the investment trusts. And that's an enrichment which remains with the managers, and it's not at the expense of the revenue. They've been repaid. It's at the expense of the investment trusts themselves. The second point, models, we dealt with it even more quickly. All the investment trusts say about why the managers have a change of defence against the investment trusts is the managers had accounted to, they say, paragraph 70, subparagraph 2a, had accounted to the revenue for the whole of the £100 of output tax. Claim by the manager to get it back. There's no need for the manager to claim to get it back. They've got it already. And in keeping it, they're enriched at the expense of the investment trusts. Now, a couple of points of interest that, in our respectful submission, make the contention of the investment trust on this change of position even more peculiar is, first of all, it's not without significance, my lords, that of the three test claimants in this case, the only party claiming that there is this difference. Footnote 12,
Yes.
this is agreed for the reasons set out in paragraph 134 of Investment Trust 1. The revenue did not make their repayments of the net amounts, i.e. the illustrative £75, conditional on the manager's undertaking to repay the ITCs the full gross overcharged amount, i.e. the £100 pursuant to those reimbursement arrangements. And in fact, that's a typographic error, 134. And if you look at 136 and 137, you can see what happened. Effectively, what happened is that at the time the question of reimbursement arrangements was under consideration, how much would you have to pass on back to the investment trusts? The suggestion by the managers was that they would have in effect, the very basis upon which, in order to prevent unjust enrichment, the revenue didn't require the full £100 to be repaid pursuant to an undertaking, was based upon an assumption about whether or not the managers would bear the £25 or pass it themselves, which proved to be incorrect.
So we'll say before the trial, but after this judgment?
No, it was before
The
the...
judgment.
So how does this...
Can I then just deal briefly with European law?
Yep.
We adopt, without repeating, the analysis of the English law position, which I made in opening on our appeal. And in light of that, submit that the investment trusts have no direct claim against revenue under EU law for at least 3 reasons. But I'm going to be very brief because the first and most obvious answer is that the principle of effectiveness requiring someone to whom undue tax has been and therefore that is an end to the story.
Can I just ask you if you can help me on one point? You may not be able to. I mean, I recollect from the test claimants litigation that there are umpteen ECJ judgments saying that limitation periods are acceptable, Denkovic, Aprile, and so on. But there's a problem if a limitation period is introduced or altered with retrospective effect,
Yes.
because it's in breach of legal certainty. Now,
We also do suggest that the point we make about the £25, if Mr. Rabinowicz's contention is correct, does produce a loss to the revenue. I mean,
Yes.
I don't know whether you want me to amplify what's in paragraphs 18 and 19, or whether it's enough just to ask you.
The investment matter.
Yes, I mean, it does leave.
Right.
I mean, the simple position is this. If the managers knew their services were exempt from VAT, the manager suppliers account to the revenue for £25 due on the supplies to the managers. The managers pay the suppliers but cannot treat that as a deductible input tax. The managers are not liable to account for VAT on the services to the investment trusts. So trusts, when wrongly invoiced for VAT. And if then the investment trust contention is correct, the revenue have then to pay £25 to the investment trust direct. So this time the revenue are £25 down compared to the position had undue tax not been levied in the first place. So that's, my lord, all I want to say about the enrichment issue. At the expense of causation. Up until...
Are you leaving European law at that point?
I'm leaving European law on the £25. Charges, Melissa would not have been enriched. Relfo, but for money being transferred out of Relfo, Vasani would not have been enriched. TFL, even in the ambitious TFL scenario, if Lloyd's TSBs were enriched at all by having a judgment in their favour saying money was owed to the assignor, not the assignee, ex hypothesi that wouldn't have happened. They wouldn't have had that enrichment without the judgment. Now, debate, therefore, has not been about whether or not the but-for test can have something substituted for it. It's been about what additional factor has been called for to make a tighter connection between the claimant and the defendant.
Yep.
And so, as Lady Justice Arden said in Relfo at paragraph 72, liability in unjust enrichment requires more than a but-for test to be satisfied, where a claimant contends that the defendant was enriched at his expense through intervention of third parties. Lord Justice Floyd, as the case had been decided on tracing grounds, said he would not want to dispense with the need even for a but-for causation if you can establish some other sufficiently tight or close connection between the payment by the claimant and the enrichment by the defendant, which, as he put it yesterday, may be even tighter than a but-for connection. So everything turns upon how you formulate the required connection. And I submit that you, my lords, need to be very careful indeed about the robustness of a test you come up with for establishing that connection without even a need for but-for causation. There is a real risk of Pandora's box being opened that makes even TfL look conservative. So what's the test? Well, on Tuesday, in answer to a question from my Lord Mance about when he was trying to defend a test of sufficient proximity, when is a sufficiently close connection sufficiently close? Mr. Rinnock proposed a close enough, and I noted this down, a close enough connection that enrichment can properly be said to be at the expense of the claimants. Well, that's obviously totally circular, non-starter. But the test he developed yesterday as the replacement of the but-for causation test was his basis test. When a customer pays VAT under a contract with his supplier, he pays it on the basis, he said, that he will pay it, or at least account for it to that, so it's revenue. And similarly, he said it to the reasoning in Menelaus, where on the basis the bank agreeing to release charges over the parent's home, on the basis of getting a charge over Melissa's house. Albeit, as my Lord Neuberger quite correctly observed, unlike in Menelaus, the customer has no legal entitlement to require that to happen. And nor, in any event, in Menelaus was that test being substituted as a substitute for but-for causation. Now, as one would expect of Mr. Rabinowitz, he put the submission very attractively indeed. So well, in fact, as to make such a bold proposition as dropping but-for causation seem almost innocuous. But let's look more closely at the robustness of such a test. Number of points. Common ground, as I said a minute ago, that there is no legal right to insist it be paid to the revenue. Second related point, nor is there in any sense a payment on condition that it be paid over to the revenue. It's not a conditional payment. It's an out-and-out payment under a contract requiring a sum of money to be paid to the supplier. So, although Mr. Rabinowitz's concept of payment being made on a basis has a reassuringly robust ring to it, it really amounts to no more than saying, in my respectful submission, that the customer assumes the money will be paid to the revenue, assuming he directs his mind to the question at all. So the connection that makes the payment between the claimant and X so strong that when it is paid over by X to the defendant can be regarded as being enriched at the claimant's expense, is that the claimant assumes that the intervening party will pay the defendant. The proposition becomes a claimant has a cause of action against an indirect recipient if when he pays the money to the direct recipient, he assumes the direct recipient will pay the indirect recipient. Now, in our submission, that is nowhere near tight enough to let loose in the law as a test of causation, even if posited as a necessary condition in addition to the but-for test of causation. But it's even worse if it's let loose in the law as a sufficient condition in its own right. Two examples. A and B are labouring under a mistake that A owes B £100. having forgotten he's paid it already. B tells A that he wants to give his daughter, C, some cash as a birthday present, but unless A repays him the debt they both mistakenly believe he's owed, he can't afford to do so. So A pays £100 to B, who gives £100 to C, and then discovers the mistake. On Mr. Ravinitz's case, A can sue the daughter for £100 simply because of his assumption that B will pay the daughter. In terms of principle, that can't really make a principal distinction between an ordinary case where money happens to be paid over without knowing the purpose. And it has enormously wide ramifications, in my respectful submission, and that's even though, on this particular example, it does satisfy the but-for test. But change the facts slightly.
Well, it occurs to me that if, an example that one would see all over London would be building sites where subcontractors provide goods and services on the basis that the contractor will incorporate them into a building and the ultimate beneficiary will be the employer. But you would circumvent or insolvency law if the subcontractor could go directly against the employer for payment on the basis of unjust enrichment.
Yes, it's another very good example.
Back to junior books and Peachy.
Yeah. Another example, change my facts slightly. You come up one with that where you don't even satisfy the but-for test of causation. B tells A in this case he needs £100 cash as a gift to the daughter. He's got £100 in his bank account, but it's more convenient if A just repays him the debt. Same facts as before. A has a claim against the daughter for £100 without even satisfying the but-for causation test, simply because he was told why the money was going to be, what the money was going to be used to pay for, was going to be used for. And my examples are just a couple of thoughts that came to me over a glass of red wine last night. Lord Reid has come up with another one already.
They're quite similar to what's in Ben McFarlane's article too.
Yes, I was reading the article over a glass of wine. As experience shows, they have a tendency to do that in ways not foreseen at the time. In short, just to think about Mr. Ravinitz's proposed test, you have to see that it's plainly not fit for purpose. As a general test of sufficient causation to make out a requirement at the expense of, let alone a test in the absence of but-for causation. And so for that reason, I invite you not to be tempted by the very attractive way in which Mr. Ravinitz put the submission. Next, can I deal with multiple claims? Two small points, smaller points. This is the interrelationship between a claim by a taxpayer against the revenue and the claim by the customer against the revenue. Yesterday, my Lord Reid asked if, in principle, if a customer to whom VAT had been passed on had claimed unjust enrichment against the revenue, in principle, but for the Section 80, would the taxpayer also have a claim in unjust enrichment? Can you conceive of two parallel unjust enrichment claims? And Mr. Ravinowitz said no, because the revenue are no longer enriched at the taxpayer's expense once the money's been passed on. They're enriched at the customer's expense because the enrichment's been passed on to somebody else. Well, that simply is not right, and I don't even understand how Mr. Ravinitz could have said it was, bearing in mind he actually referred you to the Kleinworth-Benson case, Birmingham. That's in Bundle 3, tab 38. It starts at 1554. And in fact, funnily enough, this is one of the cases that's always been referred to by those who say that indirect enrichment is, that direct enrichment is required, because if you go to 1574, the judgment of Lord Justice Morritt, he actually rules out the defence that was being sought to be run in this case. The enrichment's not at your expense, on the ground that the requirement of at the expense of, this is F, does no more than point to the requirement that the immediate source of the unjust enrichment must be the plaintiff. But the important point that the Kleinworth-Benson case established in the Court of Appeal is this. What was being said in the Kleinworth-Benson case, where the claimant was seeking recovery of monies paid under a void swap agreement, was the defendant was saying, no, the enrichment's not at your expense because you actually had counterparty trades in the market under your hedges whereby you were reimbursed the money. And therefore, it can't be said that you are enriched, that it's at your expense because you've passed on to somebody else money. And what Kleinworth-Benson established authority has not yet ever been challenged is that there is no defence of passing on in the law of unjust enrichment, and therefore the analogy in this case would be that the managers are still, on the basis of Kleinworth-Benson, as a matter of law of unjust enrichment, to be regarded as enriched. So the revenue is still to be regarded as having enriched at the expense of the taxpayers, notwithstanding the fact it could also be said, if Mr. Rabinitz's wider submission is correct, that they're enriched at the expense of the investment trusts as well. So if Mr. Rabinitz's argument is right, there is the potential for multiple exposure to unjust enrichment claims. And then you
So
can...
domestic law is different from European law, it appears. The San Giorgio
Yes,
line of cases, I mean,
that's right.
Yes.
Absolutely right, my lord. A slightly...
Perhaps the reason is that domestic law, well, is this is your argument, excluding any claim by the consumer.
Well,
So,
and of course, my lord, the law of restitution is governing more causes of action than simply causes of action relating to repayment of undue tax. A related point, the day before yesterday, when dealing with the position where the supplier elects to treat the supply as taxable, but the customer says it's not due, Mr. Rivelit suggested that the customer would not have a claim against the taxpayer in that situation because of the defensive change of position. And it was, again, I think, mentioned today in response to a question from my Lord Hodge. It said that he's got a defensive change of position because he's paid over to the revenue because he's electing to treat the supplier as taxable. And then he then sought to use that to say, well, the customer plainly must have a cause of action against the revenue in those circumstances to strip the enrichment from the revenue. And if you can do that, there's no reason in principle why not more generally. But in our respectful submission, we question the entire premise of that submission and say it's wrong. The taxpayer does not have a change position defence in that situation for a reason which my Lord Hodge, I think, floated. He has certainly paid the money over to the revenue, but it's not irrecoverable in principle. It's only irrecoverable because he's chosen to treat his supplies as taxable in his own economic interest. That's fine. That's fine, he can do that. It's his choice. But
there's no disenrichment. There's no irreversible disenrichment.
Exactly. It's a disenrichment that he chooses in his own economic interests to cause to come about, but that's a choice. If it's a choice, it can't be said to be irrecoverable so as to prevent the customers having a claim against them. We also note that were it correct, it would also give rise to a rather odd conundrum, given the whole premise of Mr. Ravinitz's case for saying that the revenue are enriched at the expense of the claimants because it's an one overall transaction. Now, plainly as regards the taxpayer position against the revenue, having elected to treat the supplier as taxable, it can't be said that the revenue was unjustly enriched as against the taxpayer. As against the taxpayer, they are entitled to keep the money because the taxpayer said it's tax due. But in order for the customer to have a claim in unjust enrichment, the very same unjust enrichment has to be regarded as unjust as against the customers. So in relation to the same transaction, it's both just and unjust at the same time. An absurd conundrum. But can I just also make one thing clear, my Lord? I want to make clear that we don't accept that the customer will necessarily have a claim against the supplier at all for a quite different reason. The customer has got to actually show not just that there's an enrichment at his or her expense, but that it's unjust. And the factor, of course, which is being relied upon here is mistake. Mistake on the grounds that the tax wasn't due. But if a contract provides for him to pay VAT, if applicable, and the supplier elects to treat it as taxable, it is due and applicable. But those questions aren't really for today.
Yep.
Can I deal next with statutory exclusion? Oh, no, can I just mention the point that Mr. Rabinowitz kindly assumed I was abandoning
Yes.
on leapfrogging the statute?
Yep.
Yes. I mean, I didn't, partly in the interest of time, not develop every single paragraph. I certainly, by not mentioning the point we make in that paragraph, was intended to abandon it
Yes,
completely.
if we made people think that by not referring to a paragraph in their written case they were abandoning it, our hearings would be 3 times as long as they are.
Quite so, my Lord, quite so. I mean, the way I put it is this. I quite see the logical force of the way in which Mr. Rabinowitz described my argument yesterday as almost incoherent, I think was the word he used. And I think he said, well, it's a rerun of the argument under the next issue. Either the statute excludes it, in which case the statute excludes it, you don't need to rely upon leapfrogging, or the statute doesn't exclude it, in which case you're not leapfrogging over a statute at all. Now, the way we put it is this. I accept that for the most part, the issue raises a question under the third head. But there is this sense in which it is a freestanding point in its own right. What the leapfrogging issue shows you is that the cause of action in unjust enrichment in itself is very sensitive indeed and concerned about not cutting across other regimes. And if it's concerned about not cutting across other regimes, it's difficult to think of a regime that can be more important even than a contractual regime than a statutory regime. And therefore, in our submission, it is perfectly open for you to fashion the ambit of an unjust enrichment remedy by taking into account the availability of an alternative scheme. And that is a different argument from simply saying it is excluded as a matter of statutory construction. But let me come on to statutory exclusion as a matter of construction. Mr. Rabinowitz's submission on purposive construction and his attack on Mr. Justice Henderson's reasoning has 2 basic complaints, as I understand it. He says, Parliament could not have had such a common law cause of action in mind when Section 24 was passed, ergo Parliament cannot have intended to exclude it. And secondly, he says, in meeting the always speaking argument, that cannot be used to fill a gap in legislation, which is what will be happening here. Now, let me take each of those propositions in turn. As regards to the assertion that Parliament cannot be regarded as having intended to exclude a common law cause of action, it could not have had in mind, that simply is not right. And although Mr. Rabinowitz referred to the Child Poverty Action Group case and told you about the case, what he didn't do is show you the case, because what the case shows you is that my proposition is absolutely right. So I need to rectify the omission by showing you briefly what was going on in the Crown Child Poverty Action Group case. And that's in Bundle 3, tab 4, at page number 1819.
1819.
Yes.
Tab 45.
Tab 40, tab 4.
Oh,
Tab 45.
Yes, so I've got a false reference. Yes, thank you, my lord.
The Child Poverty Action.
Yes.
Yep.
the basic facts of the Child Poverty Action Group case concerned the Social Security Administration Act 1992, which provided a statutory regime for recovering overpayments of Social Security made under an award where the person had misrepresented or failed to disclose a material fact. What happened is that the Secretary of State had been seeking to recover overpayments where the award gave too much benefit as a result of an error, but where he couldn't point to any misrepresentation or a failure to disclose. And it was held by implication, actually, not even by an express exclusion, that the provision was the only method by which the Secretary of State could recover such overpayments and exclude common law claims. And the point was being made, one of the points was being made very strenuously by counsel for the Secretary of State for Work and Pensions, was that at the time the provision was passed, there was no possibility of a common law cause of action available to the Secretary of State for Work and Pensions. And partly that was because the law, it was thought, was not as clear as it is nowadays, but more importantly than that, was more important than that for a critical factual reason. At the time when the scheme was first enacted, the award was made by somebody other than the Secretary of State, a functionary, and then the Secretary of State made the payment pursuant to the award. And therefore, there was no possibility of a claim by the Secretary of State that he made a payment under a mistake because he didn't actually make the assessment. And so it was said that that meant that because there wouldn't have been a common law cause of action at the time the scheme was brought into force, it couldn't have been intended to exclude it. And let us go first of all to the judgment of Lord Brown, which starts at page 1825. He goes on to set out the history in paragraphs 1, sets out the statutory provisions, sets out the arguments. Paragraph 13, he deals with the reason about why there wasn't a possibility of a mistake of fact cause of action on being brought by the Secretary of State at the time, but then goes on in characteristically robust terms in paragraph 14. As is well known, common law restitution claims are at the best of times far from straightforward. Not the least of their difficulties, a difficulty at its most pronounced in the context of Social Security benefit claimants is the defence of changed position. Part 3 of the 1992 Act provides, of course, not just for an express entitlement to recover overpaid benefit in case of misrepresentation or non-disclosure, but also for the whole process of determining the facts relevant to such entitlement, including making provision for appeals to a tribunal. It seems to be inconceivable that Parliament would not have contemplated leaving the suggested common law restitution route to recovery of payments available to the Secretary of State to be pursued by way of ordinary court proceedings alongside the carefully prescribed scheme of recovery set out in the statute. Lord Dyson deals with it slightly more fully at 1832. And again, on paragraph 22, in the previous paragraph, having set out the point about whether or not there had been available cause of action at the time it was introduced, he says, at first sight, therefore, one might think this should lead, in other words, the absence of a common law cause of action, one might think this should lead to the conclusion that the statutory provisions for recovery of overpayments were intended to be exhaustive of the right to recovery. There was no common law right to recovery. The statutory right was introduced. By definition, therefore, the statutory right to recover was intended to be exhaustive. Then he goes on to refer to an argument that was being made by counsel for the Secretary of State, which we look at the bottom of the page. Mr. Eadie's argument is directed to the true meaning of Section 1 in its unamended form, but he submits it cannot be construed as having prospectively excluded by necessary implication a right which was not in contemplation at the time when it was enacted. In other words, Parliament cannot be taken to exclude the possibility of a common law right to recovery arising in the future under a differently framed decision-making scheme. I cannot accept this argument. I proceed upon the hypothesis that, as I already said, at the time when the statutory scheme for recovery of overpayments was enacted, There was no non-statutory recovery. The statutory scheme was exhausted at that time. It carefully delineated the boundaries. So the argument appears to be it's almost the absence of any alternative remedy at the time that means that the scheme is intended to be exhaustive.
But the scheme we're dealing with can't be exhaustive so far as the £25 is concerned.
Inside the dead period. Outside the dead period.
Outside the dead period.
Yes, no.
Yes, and so far as the £25 is required, one possibility is that there's a common law right to recover that from the managers.
As I say, there is.
Yeah, and that's on the basis of that the contract under which the money was paid was defective by reason of a mistake of law.
Yes.
If that weren't the position, then there would be no remedy under our domestic law so far as £25 was concerned, but EU law would nevertheless require a remedy to be made available.
But that would be an EU point rather than a common law point. Yes.
But I mean, I was going to come to that in the EU context. There has to be an exception to 87 to deal with the EU situation, for example, insolvency, where unless you read down Section 87, you don't have a remedy in English law.
And I mean, there will be two alternative ways of doing it, my lord. You could either, by construction, disapply it to that extent, or alternatively, you could disapply it. But I agree, either way.
But you're just dealing with the exclusion of common law rights at the moment.
Yes, exactly. Yeah.
Well, except
I'm coming on to European.
Yeah, we all may have to read down any scheme to meet your EU requirements.
Yes.
Yeah.
But it's only the European dimension that even arguably can read down the proper construction.
What about the other judges in this? Do they all agree with? Yes, they agreed with Lord Brown and Lord.
They all agreed with them.
Yes.
So in a sense, I mean, that's an end to the story without even needing to go on to the always speaking point. But I also do draw force from the always speaking point. Now, the way in which Mr. Rabinovich dismissed the always speaking point was to say it's being used here to achieve the impermissible objective of gap filling. And he made the point by reminding you of what Lord Wilberforce said at the end of the passage cited by Lord Bingham as authoritative guidance. But that wasn't all he said. I showed you, in fact, what was said by Lord Wilberforce, which Lord Bingham described as being authoritative guidance. And he said that when a new state of affairs or fresh set of facts bearing on policy which comes into existence arises, it will still fall within the parliamentary intention if one or other of two tests is satisfied. The first test is, does a new state of affairs fall within the same genus of facts as those to which the express policy has been formulated? And I say, yes, it plainly does. The clear policy of Section 80, subsection 7, was to preclude claims for repayment of undue VAT except under Section 80. At the time of the enactment, that extended to the claim to repayment by the taxpayer. By no sensible yardstick can you say a common law claim for repayment by a customer is of a different genus from the statutory one by the taxpayer, especially when the whole rationale for the claim is that they are the real economic taxpayers. They may be two different species of the same genus, but it is the same genus. The other test he applies is, can a clear purpose be detected in the purpose of the legislation, which can only be fulfilled by construing the provision as extending to the new situation? And for the same reason, the answer to the first question is yes. I respectfully suggest the answer to the second question is yes also. In short, this is not filling a gap in the sense in which Lord Wilberforce, in my submission, is referring to that prohibited exercise. It is not asking what would Parliament's intention have been and then trying to read words into the statute that aren't there to fill the gap. That's impermissible. What it's doing is giving no more than a meaning to the word repay, which even the Court of Appeal thought was obviously capable of describing the satisfaction of any claim to the recovery of undue tax. And it's doing so, in other words, it's construing the word repay to cover a situation which everyone agrees it is linguistically capable of covering, so as to make it cover simply a different species of the genus to which Section 80, subsection 7, unarguably applied from day one. European law. The argument that Mr. Rivenitz advances is to say that our case is not consistent with the principle of effectiveness, not to be able to cover back VAT during the dead period or the £25. But I've dealt with £25 already, so I'm simply going to focus upon the dead period claim now. He says, to the extent that the operation of a defensive change of position is preventing the investment trust recovering the VAT, this is ex hypothesi a defence operating to bar a claim, which is no different from having no claim in the first place. And again, as is typical with Mr. Rabinitz's submissions, they are put very attractively. But what the proposition simply ignores, because it has to, is something which is common ground, actually, between us. What is common ground between us is that it is perfectly consistent with the San Giorgio principle to have a limitation period including one of 3 years, even though this can be used as a defence to a claim which has the effect of barring some or all of it. Put another way, that does not make the claimant's claim impossible or excessively difficult in the sense used in the European Union cases. And it's perfectly consistent with European law, even though it's not a defence of passing on. In short, I want to make this clear, our primary cases, there is no question of being said that the manager's European rights have been infringed as a result of not having been able to recover during the dead period. So the question becomes, for your lordships, if the manager's claim to recover undue VAT is not rendered, quote, in the sacred words, impossible or excessively difficult for the purpose of a San Giorgio claim by the taxpayers, even though it completely bars recovery for the dead period, in what sense can it be said that the ITC's claim can be treated as impossible or excessively difficult for the purposes of the Riemsfer Danfoss offshoot of the San Giorgio claim, when all it does is bar the claim to the identical extent, and where the very reason for the bar is that the change of position arises from the very EU law compliant limitation period which bars the manager's claim against the revenue. It can't be an effective remedy for one purpose, even though it bars part of a claim, but an ineffective remedy for another purpose, precisely because it bars a claim to the same extent. It's totally illogical.
Are you going to come to the Riemsfer decision? Because I'd like to, at some point, to ask you about what the Advocate General said there about the sort of exception to the principle, the insolvency as an example.
Yes.
And she goes on to say, as a result of material circumstances unrelated to the merits of the claim.
Yes.
I'm not sure where she gets that from, but arguably a limitation period is unrelated to the merits of the claim, isn't it?
Well, if it wasn't for the fact there is so much European law and law giving effect to it that makes it clear that a limitation period is the one thing that you can't complain about.
So what is she talking about there? And, I find it, may not matter in the end in this case.
Yes.
I'm trying to understand the limits. If insolvency is just an example, as it appears to me, what are the limits of the sort of impossible exclusion area?
Yes.
If it doesn't extend to a limitation.
Yes. Well, I mean, one can come up with several hypotheses, but
I mean, there's obviously someone disappearing. Like,
well, that's one hypothesis. You're simply dealing with procedural difficulties of facts that make you having an effective remedy.
that relates to them. And I find it very odd to understand quite the logic of that exception and how far it goes. That's my difficulty at the moment.
I agree, and I don't think your lordship's alone.
Okay, well, maybe that's the answer.
But the one
It seems to start from Advocate General Sharpston in Reetzma,
yes,
which is then picked up by the court in that case in Danfoss, but it's never really had to be explored or applied.
I'm not sure if it is picked up in Danfoss. Is it?
Well, Danfoss picks up the insolvency.
Yeah, I'm sorry. Yes, it picks up the insolvency. It doesn't actually pick up the unrelated to the merits of the claim formulation.
Her judgment.
Advocate General Sharpston formulates. Doesn't come up with that. But I mean, in my respectful submission, the one reason why teasing as the answer to that question may be, the one reason it needn't trouble you is, the one thing you can be clear about, not least because it is common ground between the parties, is that a limitation period is available as a defence without offending the San Giorgio principle.
Where is the reference to in Reemster in the Advocate General's opinion?
It's at page 1067, paragraph 86.
Yeah.
The last two lines. Footnote 52.
Yes, I mean, surely what it means is that you're entitled to a fair crack.
Right.
If you're ruled out for some technical reason, because there's a one-day time bar or something ludicrous like that. If you're ruled out after one day because your claim has no merits, that's different. It's been adjudicated.
Yes.
You've had a fair crack. But I think she just means that even in relation to a limitation period, I'm sure you would accept you could have a limitation period that meant you had no effective remedy.
Yes.
I think the point is that you've got the taxpayer, in this case the management company, is bust, and your claim against them would be effectively highly attenuated or killed by the fact that their claim would go from the revenue would go into their general funds available for creditors.
I understand that. I mean, I understand the insolvency example, even though you've got to construct it for these purposes.
Yes.
But she is obviously not regarding it as limited to that. Anyway, never mind it. I mean,
So I mean, I do ask your lordship to note, though, that actually in the formulation, both in Reemster and in Danfoss by the European Court, they don't say, for example.
no, they say in particular.
They say in
It's one
particular.
of those curious words. And
Yes.
look that up in French, you may find it means something different. Anyway, no, I mean, the answer is that's all we've got, and there's no point in trying to expand on it.
Yes. And if I'm right on this way of putting the case, we don't get into the territory of requiring me to justify the route that Miss Justice Henderson came down to, which was to say, well, it may be that prima facie a right is triggered, but then in fashioning the remedy, you can take into account the underlying policy behind the limitation period. But in my respectful submission, that is an equally tenable way of doing it, and is not in any way imposing, for the reasons that my Lord Lord Breed and others gave, a limitation period, different from the limitation period applicable at common law. The limitation period being the action remains the same. It is simply governing the extent of the remedy. Nor is it imposing a limitation period retrospectively for the same reason.
Thank you.
That's really all I wanted to say, other than to briefly report back on our homework that I promised Lord Reed we would do. We've tried to do some homework, and the exercise has confirmed something I alluded to in opening, which is that even in closely related common law jurisdictions, drawing comparisons on issues like at the expense of is not always easy because of the policy in different jurisdictions as to how they structure their law of unjust enrichment, which then gives rise to different tests. And I come across a good example of that, my lords, in a Supreme Court of Columbia case, which is dealing with the issue that we would characterise as an at the expense of issue. It's the normal situation we get very commonly in England, where A performs services under a contract with B, which confers a benefit on C, as for example, where A works under a subcontract with B, who has a contract with the employer C. And as a matter of English law, the claimant has no claim in unjust enrichment against the against the employer because the claimant's enrichment is said not to be at the expense of the employer. And that's actually one of the exceptions, one of the provisions in Professor Burroughs' restatement. Now, interestingly, in British Columbia, and the case is a case called Pacific National Exhibitions in Alpine Stone, but it doesn't take any matters farther to see it, the Supreme Court of British Columbia reached precisely the same result and say there's no claim against the owner. But because they divide their unjust enrichment structure in a different way from the way we do, they don't have a four-stage test. They have questions, is the defendant enriched? Is there a corresponding deprivation of the plaintiff? And is there any absence of a juristic reason for the enrichment? They analyse it in terms of juristic reason and conclude that there is a juristic reason for the enrichment because of the contract between the contractor, subcontractor, and the employer. And so even in a common law jurisdiction as close as Canada is to us, sometimes it's not easy to translate approaches to particular fact problems very easily.
No, but that's because if you carve the thing up into different headings and focus on those particular headings, you may not find your analogue in another jurisdiction. But if you stand back and look at the concept as a whole, the results that are reached can be very informative of the direction of another country's unjustified enrichment.
Yeah, well, it might be said that one of the defects in restitution scholarship has been an obsessive focus on questions of taxonomy.
You would have Professor Burke's rolling in his grave.
Yes.
Well, it's not just south of the border. This has been an issue.
Can I say that? I ought to mention this, not least because it is a case that it transpires was referred to the court in the Menelo case in the Supreme Court, albeit obviously it doesn't seem to be regarded as sufficiently interesting to find its way in the judgment. There is a case, a Hong Kong case, which was cited to the Supreme Court in Menelo, which in one sense might be said to have some bearing upon the case before your lordships. It's a long case with complicated facts. Essentially, though, what happens is this. The buyer pays the seller under what is held to be an anticipated contract for some goods. So the contract's held not to be concluded. When the goods turn up, they are rubbish. Now, as well as suing in contract and failing, because the contract was held not to exist, he sues unjust enrichment on the basis of failure of consideration. So I paid you for these goods. I haven't got anything for them. I'm entitled, irrespective of the contract, to have the money returned as upon a consideration that's failed, a remedy in unjust enrichment. One of the arguments raised by the seller is that the enrichment could not be at the expense of the buyer because of the happenstance that he paid for the goods through a letter of credit. And because he paid for the goods through a letter of credit, it was said there was no direct enrichment. Now, the court had no difficulty rejecting the argument, although the claim failed for other reasons. Because I don't rely upon it, and ultimately it doesn't take matters further, I've not brought a copy along, and it's quite long, but if your lordship wanted to see it, we could provide a copy. Those, my lord, are my submissions.
Thank you very much indeed. Well, we're very grateful to both. I beg your pardon. Of course, you've got a right to reply. I do beg your pardon. Sorry.
Oh, I will be short.
Losing the plot. Sorry.
But not that short.
My lord, sorry, we've got the references. Can Mr McNabb give you the references to European law?
I think probably it'd be better if he wrote it down and we had a piece of paper. Is that all right, Mr McNabb?
Yeah, sorry.
If you'd do that, that'd be very kind of you. I'm glad you forgot something too. Thank you, Mr Rabinovitz.
The only point I have a reply on, my lord, obviously, is the
point 4.
point in relation to enrichment. And again, your lordships will have heard my learned friend try and make his point by reference to a proposition that emerges from Becker at paragraph 44. Now, the proposition in Becker, as I identified, this is my 7th point of common ground. He made some implicit criticism that I hadn't taken you to this. It's not only my 7th point of common ground, my lords, but if your lordships go to paragraph 16.4 of our case, that's at page 180, your lordships will see that we refer there, paragraph 16.4 at page 180, to this proposition that if you want to take the benefit of not paying output VAT, you have to take the burden of not being able to claim input VAT. That has never, as I've said, I don't know how many times, I'm going to say it once more because it seems to be the only point the learned friend has, that has never been an issue. That is not what that point is about. The point, quite simply, and again, with respect to my learned friend, he went on for half an hour, he simply didn't address it. If you do make the selection, willingly take the benefit and the burden together, what is it in EU law or English law that says that as a consequence of making that election, one has to go back and treat rights and obligations which existed at the time as if they never existed or never affect? He simply is incapable of pointing to anything. All I can say is that it must be because there is nothing there to point to. I'm not sure that there is anything else I can say.
You're choosing to reply to the one point he didn't make.
What am I supposed to do? He didn't make a point.
No,
of
I'm
other
pulling
than
your
assert
leg,
inherently.
all right.
And again, he spent a lot of time not making a point. My lords, I'm not going to say anything else about it.
Well, thank you both very much for your submissions. We found this case to be exceptionally well argued, and we're very grateful to you both. We're also very grateful to those who were involved in preparing the written cases, which we also found very useful. We will consider this matter and let you know our decision in due course. Thank you all very much. Court's now adjourned.